Good morning. The January 25th, 2017 meeting of the Board of Estimate is now called to order. In the interest of promoting the order and efficiencies of these hearings, persons who are disruptive to the hearings will be asked to leave the hearing room immediately. Meetings of the Board of Estimate are open to the public for the duration of the meeting. The hearing room must be vacated at the conclusion of the meeting. Failure to comply may result in a charge of trespassing. Madam Deputy Controller, are there any corrections, additions, or deferrals on the agenda?
Good morning. For today's agenda, the board received a protest from Ms. Kim Trueheart for all items on the agenda. Her protest was reviewed by the board, however, it will not be heard. I have the following abstentions to note. There are no abstentions for the Honorable Mayor Pugh. The Honorable President Young will abstain on page 41 and pages 66 to 67. The Honorable Comptroller Pratt will abstain on page 42, and Mr. Child, Director of Public Works, will abstain on page 69, item number 2. The items that are on the non-routine agenda are pages 62 to 64, items 3 and 4, and 64 to 65, items 5 and 6. Mr. President and members of the board, that is the protest received as well as the abstentions that have been reported for today's meeting. Thank you.
Excuse me, Jackson, could you repeat which one you abstained on?
Yes.
She gonna repeat.
Page 41 and pages 66 to 67.
I just want to make sure.
Yes.
Yes.
Well, Mr. President, those are his abstentions.
Okay, thank you.
Yes.
I would direct the board members' attention to the memorandum from our office dated January 23rd, 2017, identifying matters to be considered as routine agenda items together with any correction and additions that have been noted by the Deputy Controller. I will entertain a motion to approve all of the items contained on the routine agenda.
I move the approval of the items on the routine agenda.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion is carried. The routine agenda has been adopted. I'd like to recognize Councilman Ryan Dorsey, who have joined us this morning. Thank you, Councilman, for being here. All right. The first item on the non-routine agenda can be found on pages 62 to 64, item 3 and 4. Department of Public Works recommendation for contracts, WC 1353, urgent need meter repair and replacement various locations. Will the parties please come forward?
Good morning.
Good morning.
My name is David Jarrell. I'm the brand new DPW Chief of Engineering and Construction.
Morning.
Good morning. DPW recommends that the board approve WC 1353 as we found R.E. Harrington to be the low responsive responsible bidder.
Okay.
Good morning.
Good morning.
Blake, on behalf of the protester, Metra Industries, thank you for the time. As stated in our bid protest letter, our primary challenge to the award is the responsibility of R.E. Harrington. We submit to you that R.E. Harrington is not a responsible bidder because to be responsible, it has to comply with the WBE requirement on this contract, which is 6%. In its bid, it proposed to do this by issuing a $208,000 contract to a single WBE, which is Frankie Enterprises. While certified, Frankie has not been pre-qualified and has not obtained a work capacity rating from the Office of Boards and Commissions, which is an important requirement that's also underscored from today's agenda, which reflects that on contract ER 4020, the Lower Stony Run restoration contract, indeed, that contract, all bids were thrown out, in part because they found that the low and second low bidders had exceeded the pre-qualification work capacity. So there's no question that this is an important requirement and is necessary to provide assurances to the city that a contractor will be able to perform the work in its contract. As stated, Frankie has not been qualified. It has absolutely no work capacity rating. Even though Ari Harrington proposes to issue a significant contract, a $208,000 contract to it. There is no, in fact, we set out in our letter that the information we were able to obtain from public sources suggests that its annual revenues are far eclipsed by this single subcontract alone. So the indications are that Frankie will not be able to either be pre-qualified or to obtain the necessary work capacity rating. In contrast, all of Metra's WBEs and MBEs have the proper pre-qualification and work capacity ratings, and they are capable and able and ready to perform on day one. So as such, we submit to you that Ari Harrington is not responsible and the contract should be awarded to Metra. Now, just for purposes of practical considerations, if the board moved forward to award this contract, we'd ask you to consider what will happen down the road if after award but before notice to proceed, Frankie is unable to be either pre-qualified or to obtain the necessary work capacity rating. For instance, if it obtains a work capacity rating of 50,000 or 100,000, but not enough to perform a $208,000 contract. At that point, will the contract be awarded automatically to Metra, or likely Ari Harrington will be seeking to supplement or substitute? And in that instance, we would submit to you that that would be a second bite at the apple, giving Ari Harrington an unfair competitive advantage over all other contractors that bid on this job, and would be improper and would undermine the integrity of the procurement process. So, in sum, we ask respectfully that this contract be awarded to Metra as the only presently low, responsive, and responsible bidder. Thank you so much for your time.
Thank you. Thank you.
Good morning, Honorable Board. My name is Kumasi Vines. I'm the Chief of the Office of Boards and Commissions, the office that does the pre-qualification for the city. Good morning. Frankie Enterprises has been slated on this contract to do construction management. At the time, construction management is not a pre-qualifiable category. We pre-qualify physical construction, if you're tearing down something or building up something, using a shovel, using an excavator, and we view construction management as more of project management within construction. So therefore, there can't be a requirement for Frankie to be pre-qualified in something that doesn't exist in our office. So that's what I have for that.
Thank you.
Good morning, Madam Mayor. Good morning, Madam Mayor, members of the board. My name is Robert DeShiel. I represent R.E. Harrington. I would add briefly to what what Kamasi has said, and that even if pre-qualification were required of a subcontractor, it's not required until they begin to commence work. It is not required under any circumstances at bid time. It is not required at the time notice of proceed is issued. It is not required at the time of award. So, with all due respect, the rules as suggested by council just are not the rules of Baltimore City.
May I be heard just briefly on just those new points? To start, there is no exception in the stated procedure that all contractors receive pre-qualification if they intend to perform services on a city contract in excess of $50,000. There has not been an exception stated for that. That's primes and subs. Now, they've identified an issue that apparently the pre-qualification board has not identified a specific pre-qualification category for construction management. That actually raises another point that we submitted to the agency, which is whether the stated scope of work, construction management services, is indeed an appropriate scope of work to meet the WBE requirement, and whether they would actually be performing a commercially useful function. As the general contractor or prime contractor on this contract, certainly R.E. Harrington will ultimately be responsible for managing its work and will necessarily perform project management services as it suggests. So that's just another issue. However, I think that, to suggest that because there's not a category for pre-qualification, that is wholly inconsistent with not only what was set out in the invitation for bids, but also in the stated procedure and policy that all contractors obtaining a contract over a certain level be pre-qualified. I note also that on the agenda it reflects that there's another contract being awarded to R.E. Harrington, and they are intending to issue yet another contract, much smaller, to Frankie of $30,000. So we're facing a contractor that's unvetted, unproved, and not without pre-qualification that intends to perform services for this city alone of over $238,000 without any assurance at all to the city that they are able and capable and have the resources to perform that work.
I have one question.
Ralph?
Yeah, excuse me, counsel. You said contractor. You're talking about a subcontractor, correct?
Yes.
Not R.E. Harrington, who is the prime contractor on this contract.
To the extent that R.E. Harrington's subcontractors are not responsible, that can't be divorced from R.E. Harrington's responsibility, but you're absolutely right.
Okay.
The requirement is for all contractors, whether prime or sub.
Okay, thank you.
All right, I think Mr. Chow want to say something.
Mr. Vines.
Are you finished?
Yeah.
I assume the intent of the OBC is to pre-qualify broad categories, correct?
Correct.
Okay, thank you. Mr. Corning, can you speak a bit about Frankie's certification with MWBU and or other agencies and their standings?
Sure. Courtney Billups, Chief of the Minority and Women's Business Opportunity Office. Frankie Enterprises is a duly certified MWBE with the city. They are certified for construction management. My office did the evaluation of R.A. Harrington's bid and determined it compliant because Frankie is certified for the services stated on the statement of intent. Construction management is certainly a reason related to the scope of the work of this contract, so that means they're performing commercially useful function. So we found R.A. Harrington compliant.
Are there other certifications outside of the city that they are?
They are also currently certified with the Maryland Department of Transportation. And let me also add, too, with respect to the capacity issue, one of the essential purposes of the Minority and Women's Business Enterprise Program is to develop the capacity of minority and women's business enterprises that are certified with us. So to limit them based on past performance or another contractor's consideration of what their abilities may be, that is ultimately the responsibility of the prime contractor, but certainly our program is to encourage the development and the capacity building of firms.
Okay, to the best of your knowledge of the Frankie, have they done work outside the city and or within the city itself, and how was their performance?
I'm not aware of their performance outside of the city. They have performed work for the city before, and there have been no issues or complaints with respect to that.
Thank you.
Thank you.
I may just be heard on one last point. You raised a very good point about certification. I would just make the point that there is a distinct difference between the certification process for being a WBE and the pre-qualification process, and the focus is very different. For the certification, the focus is on ownership, management. Is it being run, legitimately being run by a woman or a minority in the case of minority business enterprises, whereas pre-qualification specifically looks at their financial resources, staffing, and ability and capacity to perform the work, which essentially is the definition of responsibility. And there has not been an analysis of that point with respect to Frankie. And so there is a risk to the city, and it undermines the whole pre-qualification requirement. Thank you.
Mr. Vines.
Morning. I just want to speak to the point of the pre-qualification process. Just for clarification, pre-qualification is required for construction-related contractors doing core construction functions. Frankie is on other projects with the city, and we also have examples of other contracts that have been approved for companies not performing construction-related projects on a construction contract. For example, public outreach, communications. These are non-pre-qualifiable categories. And another point to make, Metro itself is actually pre-qualified in particular categories. When you apply for pre-qualification, we review the application, you have to list the categories that you are skilled in, and that's how we verify your skills and your experience. If the category does not exist, there's nothing to verify. And I think any other questions regarding? And I mean, of course, the board has the opportunity or the authority to grant any waivers that it chooses to in this kind of situation. But I just wanted to clarify that we don't pre-qualify marketing companies, we don't pre-qualify public outreach or communication firms, but they work on our construction contracts, especially on the design side.
Okay, thank you. I'll entertain a motion.
I move that we reject the protest and award the bid as recommended by the department.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion is carried. Second item on the non-routine agenda can be found on pages 64 to 65, items 5 to 6. Public Works recommendation for contract awards, WC 1270, water structure, infrastructure, rehabilitation, various locations. Will the parties please come forward?
Again, David Gerald, Chief of Engineering and Construction. Again, DPW recommends that the board approve WC 1270, in this case 1270, as we found R.E. Harrington as being the low responsible bidder. Thank you.
Okay, can we hear from the protester?
Mr. President, Honorable Board, good morning. Brian Kashmir on behalf of the protesting party, Spinello Companies. Spinello submits that the protest be sustained for the reasons set forth in our January 13 protest letter. In sum, it is Spinello's position that they are the lowest responsible and responsive bidder. This protest, coincidentally, also goes to the potential awardee, R.E. Harrington, but it deviates here in that this is not an issue of responsibility as to R.E. Harrington, but rather whether their response to the IFB, the response to the solicitation was compliant with and responsive to the city's requests. Responsiveness is critical to the integrity of the public procurement process. It requires a level playing field, that all potential contractors, potential awardees follow the same rules. And instrumental in that, a responsive bid submission complies. It objectively, black and white on its face, tells the city, we are going to comply with your requirements so that you don't have to guess, you don't have to speculate. It is certain. There's not the uncertainty and ambiguous nature. Here's the problem that we have in this particular case, is that R.E. Harrington's submission is non-responsive, non-compliant, but importantly non-responsive in two material respects. And one of those material respects goes to the Baltimore Apprentice Training Program. And again, responsiveness is that they have objectively told you, the city, DPW, we will comply with all of your requirements. Importantly, with respect to this, the signature page, the execution page of an affidavit in which R.E. Harrington was to sign and execute and tell the city, I will comply with this important social and economic program, was not signed. It was not executed. That failure is material. Why do we know it's material? Because on the solicitation itself, it tells the bidders, this is important. You have to affirm and acknowledge that you will comply with this important requirement by executing this page. It's not only important, it's very straightforward. They failed to do that. Also, with relation to that, the notary is somewhat suspect here. You can't fall back to the notary page because the notary says, I affirm that this individual appeared before me and they executed it. There's no execution, there's no signature. We've laid out some law here. I will tell you that yesterday, I was reviewing this, and I would submit to the board that the current pending new procurement regulations that the board is considering is very instructive on this. At section 7.7.1 of those very robust procurement regulations, it lays out the considerations for the city and the board to consider whether someone's responsive. Importantly, 2 of the 8 considerations are in play here. 2 of those considerations are where we tell you to sign, don't typewrite. That's at 7.7.1, I believe, .2, okay? That it tells the bidders that in these pending very robust procurement regulations. As well, it says that the notary is to be completed. Neither of those are to be correct. Neither of those are in place. So I would suggest that the procurement regulations that the Board of Estimates is considering right now are very telling as to these issues. That failure, it is material, it is non-responsive, and there's another one, there is an addendum in which there's some modifications to the proposal affidavit that is to be submitted, that is to be filled out and completed by all potential contractors, in which the city asks to fill out exceptions to an affidavit that goes to your debarment, your bribery, your convictions. Again, very material. The instructions to that addendum tell you it's material, tell you need to fully complete it. Again, I would suggest that if you go to the pending procurement regulations, very telling. In those same considerations, it suggests that all information requested by the city is to complete it fully. The failure to complete that affidavit fully and completely, and the failure of this signature, make this bid non-responsive because it's uncertain. What is he going to do? Is R.E. Harrington going to comply? Are there exceptions to these very important affidavit components? And for those reasons, on its face, for the integrity of the system, we submit that bid be held non-responsive. And again, unlike responsibility, this is a black and white issue. There's no question these are material terms, no question they haven't been complied with, no question they're important factors under 7.7.1 of this hopefully soon to be new procurement regulations, which again are very robust and helpful to the contracting community. For those reasons, it is Spinello's strong position that this bid is non-responsive and should be rejected, and this protest sustained, and the award of WC 1270 be given to Spinello as the lowest responsible and responsive bidder. With that, Mr. President, Board, I would ask if there's any questions for.
I do
Mr. Ralph?
Yes.
Attorney Ralph?
I have a couple questions, Council. I, of course, agree with you that responsiveness is important. With respect to the Baltimore Apprentice Trainee Program affidavit, which was attested to by a notary, correct? There was also a typed name on there. Mr. Harrington had a typed name on there, is that correct?
That's correct.
Okay. First of all, let me just say this. You understand that the regulations, and I believe you called them the proposed procurement regs, those have not been considered and taken up by this board?
Yes, I understand that. I'm saying that they are indicative of a understanding of responsiveness in the industry.
Well, maybe, maybe not. I mean, it's not been considered and taken up by this board, correct?
Yeah, they are not binding on this board as of now. I've reviewed. It was suggested that they would come up this month, but I have not seen through the board records that has been done yet.
Are you familiar with, Council, the law in Maryland with regard to marks or identifying features such as type name of corporations as being representative of a signature?
Yes, sir. What I would say is, and I would submit that even in the world of procurement, a typed signature is appropriate where there are other indications in the bid submission that the typewritten is in lieu of a signature. That is correct, but what we have here is we don't have those other indications. In contrast, and every other component of the bid where a signature or execution, physical handwritten, was done. So this is a clear omission.
But in all of those areas were they also notarized? This was a situation where you had a typed name of a corporation which was also notarized.
Yes, sir. What I would suggest is if you read the notary,
And Maryland law, commercial law, which I'm familiar with, allows that to be an assent by a corporation of their intent to be bound.
yes, but with respect to the notary, I would suggest that if you read what the notary has told the city, the notary has said.
Affirm and acknowledge.
I'll read it, sir. It says that R.E. Harrington was present before the notary and was duly authorized and executed the foregoing affidavit, executed. And as we've submitted in our protest letter, and I believe it's common understanding, an execution is a physical signature. This notary suggests to the city that happened, but the page prior to that shows that it did not.
So let me ask you about that. So we agree then that under normal commercial law, a typed signature or other mark by the corporation is sufficient in general commercial or procurement law, correct?
Well, in not public procurement, Your Honor.
Okay.
Or sir.
Okay, fine.
Too much courtroom time.
And it's been also, and it also was notarized, correct?
But with the notary being correct, yes.
Okay, so if you are correct that it should have been executed, meaning signed, do you consider that to be material or immaterial, given all the other things that we just talked about?
I believe it is material for this in this regard. One, the solicitation itself at the introduction to this tells the bidder that this is a material component. The signature is the representation, the objective black and white representation to the city that he will comply with this, that R.E. Harrington will comply with this requirement. That's not present here with respect to that. The absence of this signature is not just a minor informality. A minor informality would be one that through looking at the entire solicitation, you can see that he has confirmed that he will comply with this. And again, all other bidders did this, okay? All other bidders did this. He did not. And to make this a level playing field where everyone represents the same thing, it's not merely the absence of the signature. It's the absence of the signature as to a material component that is not otherwise in their proposal shown to be something that he's going to be complied with. That would be a minor informality. And what's the distinction here is this is public procurement. This isn't a deal between Mr. DeShiel and me to paint my house, a deal like that. This is public procurement in which the integrity of the system requires that all bidders turn square corners with the city. That's the level playing field. To ignore this and brush it aside is to say to others that, well, although we say this is a factor, although we'll look the other way. And we would suggest that that's not the system. We're not here to protest to create problems for DPW. We're here to protest to try and ensure the integrity of the system. That's why Spinello is here.
Okay.
Any more comments? I entertain a motion.
No, wait.
Oh, go ahead.
Honorable Board, Mike Mullen with the Law Department. Just a couple of points I'd like to make with regard to the Baltimore Apprenticeship Training Program affidavit. The first is that Maryland law does in fact recognize the validity of a stamped or printed signature. The federal law that was cited by my learned colleague also does recognize that. It says essentially that if there are other indicia in the bid documents that shows that the bidder intends to be bound by every part of the bid document, then a stamped signature is perfectly acceptable. That is exactly what we have here. We have a bid bond. We have the only document on my review that was not signed with an actual signature by Mr. Harrington is this Baltimore Apprenticeship Training affidavit. That's the only document. All the other ones were signed and notarized as appropriate and as required. This shows the full indication that Mr. Harrington's company is going to be bound by this bid. Also, I would submit to the board that this is an immaterial mistake, that's something that can be overlooked, if indeed it is a mistake, because this is the Baltimore Apprenticeship Training Program is required compliance if you're awarded this contract. It's a Board of Estimates resolution that created this program. Harrington will not be able to escape compliance with that program if he's awarded the contract. And if they don't comply with the apprenticeship training program, then they face very strict penalties. There's a possibility that they would be barred from bidding on city contracts for 2 years, and they would be in breach of this contract. So for those reasons, I submit to the board that the failure to actually put a handwritten signature on the apprenticeship training program affidavit, which is the only one that was not signed that way, is an immaterial error, if indeed it even is an error. Now, if the board wants me to address the other portion, the actual bid affidavit, I'd be prepared to do so.
For the record.
Yeah,
Okay.
yeah, go ahead. Yeah, yes, go ahead, man. Talk
First of
about.
all, what I'm handing out are the copies of the actual affidavit itself for the board's consideration. I think I have enough here.
And for the record, this is the second argument
This
by
is-
counsel.
Correct, second argument.
I'm good, thanks. I know what it says. I have it.
If you look at the actual language of this affidavit, the printed portions before the highlighted section ask the bidder to affirm that they have, and I'll read the first one here, that they have not been convicted of or had probation before judgment imposed as a criminal procedure article, et cetera, et cetera. And then it says, except as follows. So what the bidder is required to do here is if they cannot affirm the printed portion, and they get to the word except, on the blank lines below, they're supposed to fill in their convictions, their pleas of nolo, whatever exceptions are there. By not filling it in, they are affirming that they agree with what's above that. Now, some bidders will write in NA, some write none. Many leave these lines blank. The Department of Public Works does not reject contracts for having these lines blank because the instructions are quite clear. And again, this affidavit, if you turn to the last page of it, this was actually signed by Mr. Harrington, and it's notarized. So I would submit that there has been full compliance with the bid requirements, and that Harrington's bid is in fact responsive.
Signature. Thank you.
Further?
I don't know if
you
counsel
wanna say
wants to
anything?
respond.
I'm going to make this real quick because I know you get ready to get emotion, but I got to earn my.
Your name again, Bob?
I'm Robert DeShield. I have to earn my money, so I have to say this real quick. Number one, on your point, Mr. Ralph, just so the record's plain, there is a Maryland case that actually holds what you said. It's Invalida T. Maryland App 156, 164, 1988 case. And secondly, with respect to the bid affidavit issue, on July 17, 2013, I actually raised that same issue before the board, and it was rejected in contract number WC 1255. Thanks.
Just in brief response to a couple points. First, with respect to the affidavit at the addendum and the failure to fill in that information, I would point out that the instructions to the bidders tell them to read and carefully and enter all information required therein prior to executing. I would submit as a matter of form that all information requires some response to the question of is there exceptions or not. That was left blank. I understand now that Mr. DeShield has presented that before, and not each case turns on its own position. We would submit that that still remains, that this bid is non-responsive based on the content and form of the proposal. More importantly, with respect to the lack of signature, I will submit this. One, again, that this is a public procurement issue, not a private procurement issue. I've not had the opportunity to read the case cited by Mr. DeShield, but it didn't sound to me as if it was a public procurement case. And with public procurement, a signature where it says it is to be executed is required. Again, the notary does not provide you that assurance. The notary, in contrast, makes it more questionable. What did this notary do? Who came before them and executed anything? I think the notary goes against this, doesn't support it. And to the last point, and the final point is that, again, it is, I would submit, again, I understand that these new procurement regulations, again, which are very robust, don't go to that. But the requirement within there to be responsive is that signatures, where required, are to be wet signatures, not typewritten. And that with respect to what the Department of Law has presented to you, I would submit that there's no minor irregularity here because looking at the total, there's no single spot in this proposal in which R.E. Harrington tells the city, we will comply with this requirement. What the city Department of Law is suggesting is he needs one signature and that's it. If that's the case, then why does the bid require dozen signatures? That's all.
Thank you. A final comment?
Yeah, just one question, counsel. On the bid affidavit, it asks for exceptions to whether or not you've had a crime. What did your client put on that line?
They put on there, I believe, none or NA, and
Go ahead.
yeah, and the submission there would be there is an uncertainty. The blank creates an uncertainty. That's the problem with responsiveness. Is there an uncertainty? Is there an ambiguity as to whether or not there's been a debarment, been a conviction? It's uncertain.
But the instruction asks you to affirmatively add things if you have an exception, meaning that you have a crime. It asks for affirmative information. So you're saying that none or NA or blank there's some difference between those three when you're asked to affirmatively provide information. You're saying that that's material?
Absolutely, Mr. Ralph, because it is a physical action. You're putting none. You're answering the question. A non-response is uncertainty. That's what the city's left with this is uncertainty.
I'll move for a motion.
Yes.
I'll entertain a motion.
I move that we deny the protest and accept the bid as presented by the agency on page 64 of the agenda.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carried.
Thank you.
There have been no more business before this board is recessed until bid opening at 12 noon. Thank you.
Listen. I know, and you got a whole lot more. Audrey?
Yeah, we're ready. Oh, yes.
Good afternoon. The Board of Education is now in session for the receiving and opening of bids. I apologize for the delay. We have one addendum for today, and it is for TR 12311, replacement of 3 bridges over Maryland 295, Waterview Avenue Bridge, Annapolis Road Bridge, and Maysville Street Pedestrian Bridge Corridor, wide guide sign replacement, Bush Street to City County line. Please change the bid due date from January 25th to February 15th, 2017.
Hearing no objections, so ordered. Thank you.
TR 11013R, Lock Raven Watershed Culvert Repair, Replacement and Resurfacing. A bid bond is required if the amount is over $100,000. Excuse me. P. Flanagan and Sons Incorporated with a bid bond. $10,326,416.50. Excuse me, 50 cents. Excuse me, let me reread that, please. $10,326,416.50. Sorry.
Take a moment.
All of a sudden. Excuse me, I apologize. I think I can read this now. Okay. Again, that was P. Flanagan and Sons Incorporated. $10,326,416.50. Thank you. Thank you so much. Sorry. Thanks. Manuel Louise Construction Company, Inc., with a bid bond. $8,892,635.70. Civil Construction, LLC, with a bid bond. $7,857,814.39. Gray and Son, Inc., with a bid bond. $9,990,000.
Refer these bids to the Department of Transportation for tabulation and report.
There being no further business, we are adjourned. Thank you.